All right, today I'm going to help you out with Unit 4 Study Guide, and this is going to be Part 1. So as I go through, I'm going to read the question, and I'm going to help you out with the answer, and I'll help out with explaining extra stuff that you need to know. So question 1, blank is when a person thinks up a potential law. Whenever someone thinks up a potential law, it's called an initiative. And think about someone who has great initiative. They're like a go-getter, they're a starter. And so a lot of laws that we have out there were actually created by everyday people. Someone thought it up, they let their legislator, their congressperson know that they would like it, and then they got the ball rolling. Then the person collects signatures requesting a change in a law or requesting a new law. It is called a petition. You have to get so many signatures, and then you can go ahead and show that to your legislator, your congressperson, and then what they can do is they can go ahead and get a referendum passed. Okay, so now the below number 5, it was just cut off. It was made a mistake. So a referendum is when people vote directly on whether or not they want a bill to become a law. And so this is when you put it directly to the voters. And so when you put something directly to the voters, they go to the polls and they make the decision of whether they want it, yes, no. And that's how North Carolina got the education lottery. It was a referendum. It was put before voters, and voters felt like it would be appropriate to go ahead and help out curb the education cost. Number 2, civil law is also known as tort law. And so tort law is like your common everyday kind of stuff. It's lawsuits. So like if someone trips and falls on your sidewalk, all right, well, you're liable if you haven't been reporting like the fact that the sidewalk is messed up to the city. Number 3, in a civil case, the person who files a lawsuit is going to be known as the plaintiff. Who they're suing is now the defendant. So a civil case is a lawsuit, and the person who files it is the plaintiff. And they always file a complaint, and they do that down at the courthouse. Number 4, a less serious crime like littering or speeding is known as a misdemeanor. So jaywalking is a misdemeanor. So a misdemeanor is things that are punishable up to a year in jail. It could be tickets, fines. It could be community service. Things like that would be misdemeanors. So they're less serious offenses. And they're going to be judged in a district court in the state of North Carolina. So district is the lowest court, and it's at the county courthouse. Okay. So number 5, in a civil case, the jury will find the defendant either at fault or not at fault. So remember, in a civil case, you're always doing a penalty of a settlement. It's money. So they're not doing anything where they're going to put you in jail. You cannot put somebody in jail or prison for a civil penalty. So in a criminal case, the jury is going to find the defendant guilty or not guilty. So there's a bit of a difference in how the juries rule in civil versus criminal. In civil, the person, the defendant, is either at fault. They either caused the whatever it was, the wrong, or they're not at fault for causing the wrong. In criminal, they're either guilty, they either committed the crime, or they did not. Okay. Now, lying under oath, number 6, is called perjury. And perjury is really bad. You can go to jail for perjury. So once you've sworn to tell the whole truth and nothing but the truth, that's what you need to do. Remember, if you feel that you should not answer the question because it might incriminate you, you have your 5th Amendment rights of no self-incrimination. Number 7, in a civil case, the case can be dismissed or it can be settled out of court. So a settlement can be reached. So sometimes when a plaintiff files a lawsuit against the defendant will go to them and they'll say, look, I'll give you this amount of money and this amount of money to go ahead and we can settle it out of court. So you don't go through a lengthy trial and lengthy court costs and fees when you do the settlement out of court. Number 8, when a politician fails to do their job, the people can recall or do a recall election. So you can actually remove a politician before their term is over. This makes politicians accountable. So this happened in California. So in California, they were upset that their governor was not getting power grids built. So Governor Gray, and they went ahead and they did a recall election, and they elected a new governor. So just because you get the job and you're supposed to have the job for 4 years, you actually have to work all 4 years. So this is regular people holding their local politicians accountable. Remember, we don't recall a president. So that's something completely different. Number 9, after a verdict has been read, if the defendant was found guilty, the next step is going to be after a verdict has been read, if the defendant was found guilty, the next step is going to be the sentence or the sentencing phase. So once the jury has reached a clear, unanimous, everybody agrees that the person was guilty, then we're going to go ahead and we're going to go to the sentencing. If the person was found not guilty, then what's going to end up happening is the person is going to be released with, apologies of the court. Remember, the government, the prosecutor, it is on them to find that the defendant is guilty beyond reasonable doubt. Number 10, a serious crime like murder or kidnapping is going to be known as a felony. And anytime someone's committed a felony in North Carolina, it's going to be judged in a superior court. And in the superior court, we would hear like serious lawsuits as well. District court is a smaller court. They hear the misdemeanor cases, and that's where your small claims court, traffic court, things like that are going to be at, and they're below 10,000. But in a superior court, you're hearing felony cases and serious lawsuits of over the 10,000 mark. Number 11, unlike in a criminal case, a jury will find. And remember, it says unlike in a criminal case. So this is referring to a civil case. Okay. The jury is either going to find the defendant at fault or not at fault. So in a civil case, you either committed the wrong, your actions led to that wrong, led to that injury, or they did not. So if the jury cannot reach a verdict, and this is for civil and criminal, then the jury is going to be called a hung jury because they're split. In a civil case, remember, you only need more than half to say that the person's at fault or not at fault. In a criminal case, you need 100% to agree that the person is guilty or not guilty. So if they cannot come to a unanimous decision in a criminal case, or they can't come to more than half deciding that the person is at fault or not at fault, then the judge is going to go ahead and rule a mistrial. So anytime the jury is hung, they just cannot decide which way to go. And then a judge will go ahead and declare a mistrial. Number 12, at the blank, the defendant enters their plea. This is the arraignment. And there's the guilty plea, the not guilty, and the no contest. Okay, so if they enter a guilty plea, most likely they've made a plea bargain. And remember, people do plea bargains for many reasons, but they are making a plea bargain with the prosecutor. And the judge always has to agree to the plea bargain. Number 13, a person is notified that they are being sued when they receive a summons. So you get your nice summons in the mail, or you get served, but it tells you, hey, you are now the defendant in this lawsuit. Okay, and that's a civil case. Number 14, if a person feels that they did not get a fair trial, they can actually appeal their case to a higher court. You can't just appeal for random reasons. There actually needs to be a legitimate rule that something went wrong. So it could be that your lawyer never answered your phone calls. You had a lousy lawyer. It could be something wrong with the jury. Could be something went wrong with maybe the media, but there needs to be a procedural wrong in order for you to appeal. Maybe you got like the harshest punishment possible. That could be a reason to appeal. Like no one in the history of the world has ever had that punishment. So that could be an appeals case. Number 15, after a person has been arrested and booked, the next step in a criminal case is what we're going to call a hearing. So in the hearing, remember, you just hear the charges. So these are the pending charges against you, and it's done in a courtroom. Okay, so you are brought into the court and you hear all the things that they're holding you for. If bail is going to be set, it's going to be set here. So your defense attorney, maybe it's a state appointed one, or maybe it's one you've paid for, they're going to argue for bail. Remember, judges don't always set bail. There are reasons why they don't set bail. If you're a flight risk, like you have connections outside of this country or outside of the state, they might not let you go. If you are a person who is facing huge charges, like that are possible death penalty charges, they might not let you out as well. So it's just one of those things where it's a case by case example. Also, if you're a criminal who has a lengthy record and it's violent, they might not let you out on bail, because while you're out on bail, if you commit more crimes, then it's not going to look good on the court that they let a guy or girl who has charges pending out. So number 16, when the Supreme Court of the United States rules on a case, the winning decision is going to be the majority decision. And remember, there's 9 justices, so there's always a winning decision. It could be that all the justices agree, but it doesn't always work that way. There are cases where all of them agreed, like Brown versus Board of Education, where everybody was on the same page for the same reason, and that was a majority decision. Sometimes there are justices who disagree with the decision, and they're going to write a dissenting opinion. They do not agree with the ruling. They have a different take on it. Okay. So one of them, or just the one, is going to go ahead and write why they don't agree with the rest of the court. Sometimes justices agree with the winning decision, but they don't agree for the exact same reasons. They agree for a different reason. Could be a different law, could be a different amendment, but that would be a concurring opinion. They concur that the decision is right, that yes, whatever was the decision, but they don't agree with the reasoning behind it. Number 17, the court calendar is known as the court docket. So the court docket is just going to tell you when you have to appear in court, what courtroom. It lays it out. And remember, you're supposed to have a speedy trial, okay, as quick as they can get it. Number 18, in order for the Supreme Court of the United States to hear a case, they must agree to hear it, and they're going to issue a writ of certiorari, and all it is 4 of the justices have believed that your case should be heard by the Supreme Court of the United States. So it's that rule of 4. And number 19, when a bill is introduced to one of the houses of Congress, it's going to get assigned to a committee. So a congressperson, a legislator, has introduced this potential bill. It could be about education. So it's going to go to a committee of experts on education. And once it goes to the committee, it's going to go to a subcommittee within it, someone that might specialize on, school safety. So those people, those congresspersons, are going to work on that bill. They're going to try and perfect it, and then they'll suggest to the committee, hey, we think this looks good, and then they'll go forward from there. Number 20, if the accused feels a case is solid and the state will get a conviction, the accused might accept a plea bargain for a lesser sentence or charge. Sometimes prosecutors offer it. They don't always offer it, but it is a win for them. It saves time and money of the taxpayers. So a lot of times prosecutors like to do it. And if they do have a pretty solid case, a lot of times you'll see people who are being accused of a crime take it. Number 21, police have a search warrant in order to gather and collect evidence from the accused or the suspect's property. If police find something incriminating, like there's definitely something there, like they find blood, they find the murder weapon, the judge will go ahead and issue an arrest warrant to officially take in the suspect, to be booked, and to have a hearing or whatever else needs to be going on, okay?